So today's question is, are patents classified? And I think this question talks about, are they confidential and secret beyond what the public can access? And the answer is yes at first, but not for long. So when you file a patent application with the US Patent and Trademark Office, it is not part of the public domain. And depending on what type of application that you file, some types are never published, where other types are published only if you do not file what's called a non-publication request. So let's start with what are not published. And those are provisional patent applications. This is a type of patent application that must be followed up by a non-provisional formal application, at least within 1 year. A provisional really is more of a placeholder, and it will lock in what's called the filing date for an inventor. And they have up to 1 year to file the non-provisional that can make reference back to it. And that non-provisional, that more, call it complete application, will have the full list of claims, all the supporting documents, the oath, the declaration, and all the correct figures in the right manner. But the provisional can be very informal. You can submit sketches, and the descriptions can be quite natural language without having to get more nuanced and break out the sections and be particular about how you do your figures, as well as all the different drawings. When it comes to what does get published, the non-provisional, that more formal application, that will get published 18 months from the earliest filing date. And so if you did file a provisional 1 year ago, that non-provisional application, the whole thing, will get published 6 months after filing. But if you did not file a provisional and you file the non-provisional straight away, it'll still take 18 months. So 1.5 years from when you originally filed that non-provisional. So I think that helps answer your question. There is a totally separate area of patent law which deals with classifications. And if this was the intended question, I do want to talk about this briefly, that once you submit a patent application, it'll get reviewed by the clerks and the examining group, and it will get assigned to specific what's called technology centers. And there are about 9 technology centers at the USPTO, ranging all sorts of different fields, right, of technology. For example, Technology Center 1600 is about biotech and organic fields. Technology Center 2100 is about computer architecture, software and information security. Tech Center 2800 is about semiconductors, electrical and optical systems and components. And Technical Center 3600 is about transportation, electric commerce, construction, agriculture, licensing and review. There's mechanical engineering, there's communications, computer networks, cryptography, lots of different things in different technology centers. And the main reasons for this is examiners, they have backgrounds in each of these different fields. And so they will spend likely their whole career as an examiner within just one specific technology center. So they can become more and more familiar with the state of the art and make examining more efficient, right? And they'll actually, in the same area, same subject matter, I should say, so they can become experts and really have developed a bit of a expertise and a tradition in that section, so they can move through the prior art, move through the application much quicker. All right, hope that answer your question about classification of patents, whether that means secrecy or whether it's published, or whether that means breaking them out into different sections. Have a good day, everybody, and go big, go bold.